Ladies and gentlemen, boys and girls, and that one cat from Connecticut, I am sorry to announce today that today's program will proceed. I have warned Alan that it's not a very good program, and from the few of you here, I can see that you agree. So what you may want to do is send an email to Gassman@gassmanpa.com and say, please end this Saturday program. Hardly anyone is watching, and even those watching don't enjoy it. So as we go forward, please oh, hey, how's it going? Hey, Alan, how are you? Oh, I'm fine. What were you doing? Oh, nothing. I was just telling the audience how good this program is going to be. Oh, good. I'm glad you agree. Why don't you go get some work done, and I'll talk to the audience. Okay. Bye, everyone. Don't tell them what I really said. Okay. Oops. Welcome to today's program. It's 11 a.m. on Saturday, September 17, and we're going to talk about trust arrangements for children and what planners and their clients need to know. So I pulled together quite a few different items from different presentations to give you some ideas on what to do for children. And this, of course, assumes that you like your children. In about 59 minutes, we're going to play a presentation that was especially videotaped yesterday just for today, and that is Travis Fincham's discussion of Medicare and other eligibility planning, what estate planners need to know. So very much appreciate Travis's willingness to provide this for us, and then he's willing to come back and do a 1-hour presentation, and you can consider this to be the basic presentation that he can spring from. Okay, this is not for credit today. We submitted it for credit, but it just wasn't good enough. So the accreditation people said, they recommended that we don't even give the presentation. And CPA Academy even said the same thing. Don't bother us, Alan. This isn't such a good presentation. Next week, though, Brandon Ketron and I will talk about planning with charitable remainder trusts. And then the following week, I'm really excited to have Larry Katzenstein join us at noon for a demonstration of his baby, which is Tiger Tables software. And if you've never seen Tiger Tables and you're an estate planner or you have an interest in estate planning, you should definitely join us. And I'll be talking on the mathematics of estate planning. Wednesday, September 21st, coming up, I get to talk about 50 ways to leave your legacy for charitable planning strategies that you forgot or didn't know about. I hope I can put some interesting things there for you. And we can give you the registration information if you need it, or you can click there somehow and join this really good program and support the UJA Federation of New York and all the wonderful things that they do. So, as one of my favorite authors, Robert Heinlein, said, don't handicap your children by making their lives easy. And we see this over and over again. I'm in about my 40th year of estate planning, so I'm actually able to see a lot of children who were born while I was representing their parents. I've been able to see the approaches that their parents have taken, or the lack of approaches that their parents have taken. And I can tell you that if you want to ruin a child's life, make it really, really easy and give them everything they want, and don't make them work for anything. And you can definitely ruin their life. If that's your goal, it's an easy goal to meet. You just need to be consistently inconsistent. And by the way, set a terrible example. So I met yesterday with a longtime client who's become a friend, and he has 4 children, and they are all self-supporting. They all are living meaningful lives. 3 of them have children of their own. They're in 4 good marriages. And I said, number one, you and your wife did a fantastic job raising them. And number 2, you're a little bit lucky too. and he completely agreed with me. But he said the most important thing was that he always made sure that his children knew that they would need to be economically independent. He would pay for a great education, but when they lived under his house, they had to live under reasonable rules. And when they went out into the world, he would pay for education and nothing more, nothing more, despite an ability to pay for more. And his children all took that to heart, and they are now all building their fortunes without his financial assistance. And that puts a lot less pressure on him and a lot more love into the equation, not just about money. Okay, a couple of items in the news I just wanted to cover, not having necessarily to do with children, but as you know, the estate tax exemption of $12,060,000 goes up every year by chained inflation. Now, that's not full inflation, but it's about 2/3 of inflation if you want to boil it down. So this recent article in Steve Lineberg's newsletter system talks about what may happen. So the good news is the exemption is going to go way up. Of course, it may come down to half in 2026, which is what the law now says. And that could even happen sooner. But it looks like we'll have a bigger exemption. But with inflation, the assets are going to be worth more also. So it's still interesting. Secondly, I released an article onto the Lineberg system September 12th. There have been some new cases in Florida where judges have allowed creditors into homesteads, but that's when the debtor uses what we call ill-gotten gains. So there was an article that came out recently that said that this homestead exemption in Florida for creditors may be getting peeled away or reduced. I don't think that's the case. So this was our polite rebuttal to that article. Well, September 13th, I had the honor of speaking to a group of 37 very motivated high school students. And what we called it was professional and personal acceleration, getting a jump start on your career and life. And I got to spend 50 minutes with those 37 students, and it was a real pleasure. And the first thing I told them was, I'm going to give you the same talk and the same workshop that I give to lawyers and doctors, and that I've given these throughout the country. And all I can tell you is these 37 sophomores, juniors, and seniors got it completely. They went straight into what they wanted to get out of life, what their biggest time wasters were, and what habits they would need to do well and to enjoy life. We went into breakout sessions. They went into session groups of 3, a lot of it with groups of 3 people in the school who they had never met. Shyness is prevalent there in all schools. We talked about shyness. We talked about communication skills. And quite frankly, we did a lot in 50 minutes. But the most important thing we did was I got them started on setting their goals. Now, their goals are certainly different than a typical lawyer or doctor or business person's goals. But believe me, if you remember being in 10th grade, you need some goals. You need some light at the end of the tunnel, and you need some exciting life goals. Can you imagine if when you were in 10th grade, you knew more then that you know now? If you had only had that extra knowledge and you had done the right things, what could have happened? Well, these 37 high school students, they got it. So if you have a child or a grandchild and you can get them talking about their goals, writing down their goals, writing down what it takes to do what they want to do, that's so much more valuable than buying them a car and taking them skiing, maybe even taking them fishing, talking about what they want to do in life and what their goals are. And if you're a grandparent, to tell your stories to them, they may not be listening actively, but you are a big hero to them. So take that to heart. What you can give somebody, what you can give a child, is the ability to aspire to greatness and to have confidence and love. That's very, very, very important. and money too, of course. So think about what your problem is with your child or grandchild, what the ideal solution is, the causes of the problem, and how you're going to handle the problem. Don't let your children go astray because you haven't given it enough thought, you haven't gotten enough coaching, whatever that takes. All right. Thank you, Kiran Patel, for funding Kiran Patel High School. What a beautiful high school in Tampa that is. It's a charter school. The kids are there because they want to be there. And Kiran Patel, I assume, struck a pretty big check and got very active in how he wanted a high school to educate young people in Tampa. So hats off to him, and hats off to those 37 students that I met with. And I mentioned Dale Carnegie and how to get along with people. You smile, you make some eye contact, you say nice things, not bad things. You tell them something about yourself. And they thought that it was a great idea. Now, from the presentation, Avoiding Estate and Trust Litigation, this we see a lot, and that is how to handle the children with the second marriage. And it's difficult to think through and to carefully think through that these children of your spouse may become big problems or may become important allies. So they're just kids now, but when you're elderly and infirm, they may become your protectors or they may become coyotes. So just give that some thought. I had a recent conversation with a client who said, well, my spouse wants me to treat her children the same way I treat my children so that there won't be jealousy. But that would be expensive because I treat my children pretty well and her children may not be as deserving as my children. Well, those are tough situations to be in. If you're going to remarry and you can find someone without children, that's probably the best idea. But when you have the second family, I just want you to be aware that your chances of litigation or unhappiness go up if you don't treat all the children equally. And even then, it may not be enough. A lot of people pull for their own children and not the other spouse's children. It's something to get on the table. The second thing that we've discussed a lot in the past is that if you have a child, I will say out of kilter, a child who's a little bit of an outcast, a child who just quite hasn't made it on their own, a child who's resentful, a child who has more addiction problems than the other children, well, when you have your stroke, they're going to come and move in with you, and they're going to take control as soon as they can. So you want to protect yourself as carefully as you can. I can't tell you exactly how to do that, but I would at least expect it and make it clear to family members, to trustees, and to everybody else that I do not want this particular person or these particular people to be in charge of me if I become infirm. There's studies that show that people make the best decisions in their 40s and 50s, okay decisions in their 60s and 70s, and not so good decisions in their 80s. Now, I'm 63. I'm thinking, wow, I've never been so smart as I am today. I was really dumb 20 years ago, but other people may have other opinions. So if you have a child out of kilter, or you have a child that is taking a lot of your time and energy, maybe give it more time and energy and get it resolved. Remember, your children, if they're small, they listen to every word you say and they emulate you whether they hate you or not. And then when they're grown up, they go their ways. They get influenced by spouses or significant others or by cults or who knows what. So love them, but please do protect yourself. So going to that, I give a talk every year for vascular surgeons. And one of the things I talk about is I say, your biggest financial threat may be your children. I mean, I went to a 100th birthday party, and the man who was 100, who gave his own party, had to pick up his daughter on the way there and bring her because she wasn't able to get herself there. So then I counted 47 of us. He knew us all by name, and he gave a 45-minute speech. But his biggest issue was his daughter, who could not be self-supporting in her late 70s. So I tell the doctors, imagine a big shark or a remora holding onto my abdomen, and there's blood coming out, and I can't get this remora or the shark off my abdomen. That's your kid. So whatever it takes to make them self-sufficient. You know what? It takes a long time to help a kid tie her own shoe. It's so much easier to tie her shoe for her or to get her Velcro. But what the loving is teaching that child to be self-sufficient as best we can. So I just bring that up because it's so much easier to throw money at caretakers, throw money at schools, throw money at drivers, and then throw the life away of a young, talented child who had everything handed to them. Share your passions with your children and grandchildren. Please don't go home every night and say, I would never be a doctor. It sucks. It's terrible. I hate it. You think your 10-year-old isn't listening to that? What do you think your 10-year-old's going to be? A banker who makes 1/4 of what a doctor makes? Some of my best friends are bankers. I'm sorry. But I think you see the point. Have a positive attitude at home and make sure you understand that you're on stage. And if you don't love your job, do something about it. Don't take it out on your children. Very, very successful children often have had parents who set a great example because they were hard workers and passionate about their work. I have clients who tell me, I used to wake up every morning, or a client would say, I used to wake up every morning, and there at the kitchen table was my dad doing his work. He was a prosecutor. And then as soon as we got up, he put his work in his briefcase, and then we had breakfast, and then he went to work, and sometimes he worked late, and then he would tell us what he was able to tell us, and he loved his job the same way that I love my job. So hopefully I'm not out on a tangent here. I know I haven't talked much about taxes yet. How to use Excel. A lot of people say, oh my gosh, Alan, you have so many good Excel spreadsheets. How do you do it? Well, I find high school kids to put them together because I have no idea how to do Excel. I just know column by column. If I tell a 14-year-old what I want in each column, I can get a great Excel spreadsheet. So work with your grandchildren, put them to work. They're very, very smart. So how does this all fit in the estate tax world? And I just want to, for those of us who aren't estate tax experts, remember the first dying spouse can put up to $12,060,000 in a family trust that never gets subject to estate tax in the second death, no matter what it grows to. And then the surviving spouse will also be able to put a certain amount in trust for children that will never be subject to estate tax. So my most important advice that I give the most often is do not leave an inheritance directly to your child. And then when I represent the child, I say do not accept an inheritance directly. Have mom and dad place that inheritance under a trust. Now, we often call them generation skipping trusts. They don't skip the child, they skip the tax at the child's level. So, Grandma, thank you so much for giving my child $1 million. Why don't you leave it to me as trustee for my child? And we could say that when I'm gone, my child can be her own trustee. She can get what she needs for health, education, maintenance, and support. She can direct where it goes when she dies down our family tree, but let's leave it in trust for her lifetime. Why? Then she can't lose it to a creditor. It's not going to be subject to estate tax when she dies, and she's not going to lose it to a spouse the same way she would if she could put it in joint names. And then if you have her be required to serve as co-trustee with her choice of any licensed trust company on earth, and you have guidelines that say, oops, she can't get out more than $12,000 a month unless she needs it for health or education. Otherwise, she should really work and enjoy life. Or if she's spending time raising children, give her an incentive. But again, as Robert Heinlein said, don't ruin your child's life by making it easy. So we have many clients who we offer sample clauses. And one of the sample clauses we offer is my child should not get more than a certain amount a month upon reaching a certain age after being educated, should be self-supporting 5 years before she could ever serve as a co-trustee for herself. And if she wants these benefits, she should spend 20 hours a week in charitable activities. So these are all sample clauses that we commonly use to cause the sample. It's the sample the sample clause, not Santa Claus. So, many clients do say, I've got 50 million and I've got one child. Maybe I'll leave 15 million in the trust for her and let her administer a charity with the other 35 million. Maybe that will give her a better life than if I throw 50 million at her and Uncle Sam takes 20% of that. So just thoughts. Most of you attending this presentation are planners. If you don't have these conversations, the clients will think that the thing to do is they say, oh, well, where's the age 35 thing? And I say, what's the age 35 thing? Well, don't they get it at age 35? And I say, not anyone I know will leave a child a lot of assets at age 35. You may have been mature at age 35, but I have clients who aren't mature when they're 95. So on and on it goes. All right, let me just show you some numbers here. I have the Estate View software. And by the way, I haven't been showing Estate View very much because it's in the middle of some improvements that I'm very excited about that I could tell you about later. But you have Bob and Mary here, and they have a $3 million home, 10 million of investments, and the investments are going to grow at 8%. The home's going to grow at 3%, and they're going to gift $32,000 a year to an irrevocable trust. So if they do no planning, then on the second death, they're going to have a very large estate, about 42 million, and Uncle Sam's going to get 9 million. On the other hand, I go here and I just say they have one child. While they're both alive, they'll be giving the equivalent of 32,000 a year to a trust for that child in cash. And what will that do over a period of 20 years? Well, I go to annual gifting, and there's the gifting trust, and it is significant. That little 32,000 a year for the first 10 years, and then today's equivalent adjusted for inflation of 16,000 a year for another 10 years. That's $1.5 million. That's for one child. That's pretty good to avoid estate tax on $1.5 million. Now, what if I give LLC interest? Let's say I give discounted non-voting LLC interest and I take a 30% discount. I go here to discounted gifting, and this goes from $1,547,000 to $2,210,000. And what if they have 2 children? So I can go here to gifting and put my exemption to 2 children. Let me see, did I do that? Yep. And then it doubles. So now you've got $5.6 million. So these little annual gifts, whether you make them into an irrevocable trust or you make them into a 529 college savings plan, it's important. Now, I don't rely completely on 529 college savings plans if the client is wealthy, because remember, what you pay directly for tuition doesn't count as a gift for gift tax purposes. But it does make sense to put assets into 529 college savings plans. There's 2 types of 529 plans. The first one is a prepaid plan where you give money to the state of Florida, for example, and you're guaranteed tuition and or room and board or both if you go to a Florida school. And then there's reciprocity with other schools, which of course are not as good as Florida schools. So, which is hard to believe I said that, isn't it? The other kind of 529 plan is really a tax advantage mutual fund plan. And what Internal Revenue Code Section 529 says is if you put money in this plan and you spend it on anyone's high school tuition up to $10,000 a year, college tuition and living expenses, graduate school tuition and living expenses in a reasonable manner, then you never pay income tax on the internal buildup of that 529 college savings plan. So, you know, a lot of wealthy people come to me for planning and they say, oh, I'm putting $75 a month into the college savings plan for my granddaughter. And I say, just fund it fully. If you think $100,000 is the right amount, your granddaughter was just born, you put $100,000 in there, it'll double twice on average. So it'll be worth $400,000 when she is 20 years old. That would hopefully pay for a lot of college if you also pay the tuition separately. Why not have all that money growing tax-free as opposed to funding it slowly? I mean, if you can't afford it, that's one thing. But the other thing about the 529 plan that I really like is it is revocable. I put the $20,000 in the 529 plan, and it's for my granddaughter, and she is not respectful. It changes. You could change the beneficiary once a year to your next door neighbor or a needy person, or you could just spend it yourself and say, you know what, grandchildren, you don't need it, you don't deserve it. I'm going to go on vacation and spend your 529 plan. So when you take the money out of the 529 plan for your own purposes, you pay income tax on the buildup plus a 10% excise tax. But the fact that you've deferred the tax for all that time can actually make up for the 10% excise tax. So I could argue and show you numbers that say even if you do a 529 plan and you spend the money on yourself, it was creditor protected while it was in there, according to the law of most states, and also to a certain extent under the bankruptcy code. And you end up spending it, take it out when you're in a low tax bracket, and it's actually almost as good as a deferred annuity. And a lot of people buy deferred annuities for income tax planning. Now, I'm probably totally wrong on that, because when you take money out of a 529 plan, the worst comes out first, and it's ordinary income. But if in doubt, and you have people you love who you may educate, and then people who aren't even born yet who you may educate, 529 plan's a nice thing. Now, do you have to choose between the 529 plan and putting other things into a trust? For example, if I put $16,000 into a 529 plan, I can't get a discount. It's not going to grow as fast as a LLC interest that I can put into a trust for my grandchildren. So do I have a choice? And the answer is you could do both, because your family LLC could buy the 529 plan and then it's not a gift. So if I have $1 million already in a trust for my grandchildren, that trust could buy a 529 plan for each grandchild at $100,000 each. That's not a gift. And then I can continue to make gifts of discounted LLC interests to trusts for the grandchildren. So the 529 plan does not have to be direct. Yes, you can forward average with the 529 plan. So instead of $16,000 a year for 5 years in a 529 plan, I could put $90,000 today in a 529 plan and say, dear Uncle Sam, this is my $16,000 gift for my granddaughter for the next 5 years. But actually the numbers come out better if you do discounted gifting every year of LLC interests, and then what I call the bang funding of that 529 plan initially, based on the numbers that we've read. Now, I want to mention, some of you did fund a 529 plan before the market plunged. So now you've got a $100,000 tax basis in that 529 plan, and it's only worth 80,000. And here's my advice to you. Put 100,000 in a new 529 plan, and that's going to be your 529 plan. Consider the old 529 plan as a tax shelter, because the first 20,000 that $80,000 529 plan earns is tax-free. So I put a new 100 in a 529 plan for my granddaughter, and the $80,000 one with a 100,000 basis. When it gets to 100, I take the 100 out, and I've saved capital gains tax on that 20. And if you use the inexpensive 529 plans, which are available without sales charge, without surrender charges, that can make a lot of sense. I especially like the idea because as far as I know, I'm the only one who thought of it. And maybe I'm the only one who's done it, but it looks good in peer-reviewed research, doesn't it? Okay. So going to the presentation that Denicolo and I gave on May 28th. I know a lot of you were on the presentation, but you fell asleep. The Teapot Trust, another thing that Chris and I kind of invented. And here's what happens. You have a client who has a lot of IRA assets, and they leave a third to each child. Well, one child is the neurosurgeon in a high tax bracket. One child is the school teacher in a middle tax bracket, and one child is in a really low tax bracket. So wouldn't it be better to leave the IRA to the low bracket child and leave other assets to the other children? And that may be your answer. That may be a better thing to do. Just leave the IRA to the low bracket child, and then in your trust say, I want my other assets to be allocated among my children and take into account that my lowest income child got the IRA. But that's not complicated enough. That doesn't give me anything to draft or administer. So we kind of came up with this idea of the Teapot Trust. So you leave your 900 IRA to the Teapot Trust, and then you leave, in our example, $1.4 million to an equalization trust. And then the trustee meets with the 3 children every year for 11 years and doles out the Teapot Trust in the best tax way based upon how each child is doing each year. And also at the same time uses the equalization trust to equalize it out. So, it may turn out that the neurosurgeon is in a low tax bracket because he gives a lot to charity. Or he may take a sabbatical for a year and want that IRA to go to charity. So things can change, but with the Teapot Trust and the Equalization Trust, the children can meet once a year. The child with the best habits in investment and smarts can rub off a little bit more on the other children for the 10 years. If they blow the rest of their inheritance for the 10 years, they would still have the Equalization Trust after the 10 years. And there's even a song on YouTube. If you search Gassman Teapot song, you'll see Kristen Sweeney not only singing a song, but also juggling a child in a very safe way. Okay, so that is the Teapot Trust. Think about where you're going to leave that IRA. Is it better to go to charity where charity doesn't pay any taxes? Is it better to go to your spouse, which is usually the answer if it's okay if they roll it over, but then how to allocate it among children. And by the way, thank you for being here. Thank you for your questions. If you'll ask some questions, and yes, James, go Iowa Hawkeyes. I get it. Was that Alan Alda? Okay. Is a 529 distribution taxable in the same calendar year as the child receives the scholarship or grant? No. If the child gets the scholarship or grant, you leave the money in the 529 plan. If you don't use it, you can use it for your grandchildren or some other body's grandchildren. Some other body's grandchildren. It's probably not very good English. Okay. Well, besides the beer that made Milwaukee famous, I made Milwaukee famous by talking about 199A and 678 trusts. for the Milwaukee Tax Club. And I appreciate the opportunity to have done that. So under section 199A, if you have a certain kind of business, then the income from that business is eligible for a 20% income tax return deduction. So instead of being in the 37% bracket, you're going to be in the 29.6% bracket. But if you have a professional practice, like you're a lawyer, a CPA, an architect, a masseuse, then you don't get the 199A deduction if your income is over certain thresholds. 170,000 if you're single, 340,000 if you're married. Or these thresholds apply if your business doesn't pay enough wages or have enough what's called qualified property. So, and by the way, the specified trades or businesses include actuarial services, performing arts, consulting, etc. So what I can do is, if I'm in a high bracket and I own this business and I can't get the 199 deduction, I could give parts of the business to my children, and if they have under these taxable income amounts, then they will not only get taxed on this at their lower brackets to some extent, as we will discuss, but they will get the 199A deduction. And then I don't have to actually put this in the name of child one or the name of child two. I can put it in what's called a section 678 trust. How does that work? I set up a trust for my daughter, my granddaughter, and my wife. I make the daughter or a friend the trustee, not my wife, and I give my daughter a one-time power to withdraw everything that's in the trust within 30 days of funding the trust. My daughter does not exercise the power because I asked her not to, but now that trust is considered as owned by my daughter for the rest of her life, whether she gets distributions from the trust or not. This is assuming that the trust is properly drafted, and it's not easy to draft this. You can't just Google 678 trust sample or buy one on the internet. You have to actually hire a lawyer to draft it, and the lawyer needs to draft it very carefully. But in any event, here's what happens now. Child one, let's say child one is a school counselor and she makes $60,000 a year. And then she makes another $100,000 a year of distributions from the 678 trust, from the company into the 678 trust. So that 100,000 of income tax, she's going to be taxed at most 29.6%, actually much less than that. So, sorry about that. So she's going to be filing a tax return, and then she's going to need money to pay that tax. So then the 678 trust can make a distribution to her of an amount sufficient to pay the tax, and then maybe a little more if you want to. The interesting thing is, if she misbehaves and you're mad at her, then she gets the taxable income on her tax return, but you don't have to make a distribution. That's pretty good leverage to have over your child. So, but you may say, aha, if the child is under 24 and not a full-time and a full-time student, then the kiddie tax comes up. Now, I know most of you thought that the kiddie tax was a tax on cats, and it started out as a tax on cats, but soon the political parties both realized that you couldn't tax cats unless you taxed dogs, and people who like dogs weren't going to stand for that whatsoever. So they changed the kiddie tax so that it became a tax on children. And the old kiddie tax said that if you're under 18 or you're under 24 and you're a full-time student, then your income above about 12 grand a year that's unearned because you got part of ownership of a company is going to be at your parents' tax bracket. Now, that was really complicated. So they changed that, and then they changed it again. So what it is now is you just get taxed at the 39.6% bracket. So I'm 24, I'm sorry, I'm 23. If you're 24, this doesn't apply, but I'm 23 and I have $100,000 in dividend income. So, and that's my only income. 12,000 of it's going to be taxed at a lower bracket, save me about $1,600 in taxes. Not a big deal. But the rest is going to be taxed at the normal bracket. But the thing is, if it's a business and grandpa's in the 39.6% bracket, or my parents are, and I can be in the 29.6, and it goes into a 678 trust, this can be a neat thing. Now, there is apparently a way to beat the kitty tax, and that's not to get a dog, although children should have dogs, and probably I should have a slide for that. Dogs absorb stress and give unconditional love. Okay, but the kitty tax does not apply to a child who is not a full-time student. So one strategy is just tell your child to drop out of school. And Timothy Leary gave that advice. Maybe he was doing tax planning, I don't know. But nobody takes me seriously when I tell them to advise their grandchild to drop out of school until they're 24. So the next piece of advice is the kitty tax doesn't apply if the child provides more than half of their support. So you go ahead and give the child a big gift in 1 year from the trust you already set up for them, and tell them for the next 3 years to provide more than half of their support. And then the kitty tax doesn't apply, and they can afford to get a dog. So that is the 199A savings. So the savings can be pretty darn significant. I mean, if you have a high income taxpayer, she can't get the 199A deduction on 169.5 of income. She's paying 69,000 total taxes when you include the Medicare tax. Whereas a lower bracket taxpayer in the 20% bracket is going to pay 37,000 in tax. So without a 199A deduction, but with a 199A deduction, you're talking about 13,000 in tax. So the savings are $45,000 per year per grandchild. So it's worthwhile to get your arms around this and think about what works best. So what I just mentioned for your children is a Section 678 trust. And while the 678 trust can own S corporation stock, and then the S corporation income is taxed to the child. The alternatives, and a couple of you asked me specifically to cover the difference between a grantor trust and a complex trust, and then S corporation stock ownership, because as the advisors know, most of our affluent clients have S corporations and pay tax on the income that happens within the company. So with a grantor trust, I set up an irrevocable trust. I'm the grantor. And when the trust is irrevocable, it could still be considered as owned by me for income tax purposes if one of several things happens. For example, if I retain the right to replace trust assets with assets of equal value, that irrevocable trust can be outside of my estate for estate and gift tax purposes, but nevertheless, I pay the income tax on the income, and my payment of the tax is not a gift. So that's a nice thing. It's a grantor trust, but I'm taxed at that income at the highest bracket. Now, another type of trust is the 678 trust, where my child is considered to be the owner of the trust. It's important that the trust be carefully drafted. And now everything's taxed at my child's bracket. The next kind of trust, and either of these, if properly drafted, could shift into it, is the complex trust. Now, the complex trust, it's not all that complicated. But for some reason, that's what the income tax literature calls a trust that is taxed at its own bracket on the income that it keeps. So imagine a pitcher of beer. You pour the beer into the pitcher and you have the suds at the top, and that's the income. And if you leave the suds in the pitcher, then the pitcher has to pay the income tax on the suds. But if you pour the suds out to a beneficiary, the suds that go into that beneficiary's glass gets taxed to the beneficiary. So if the trust has 50,000 of income and it gives 10,000 to beneficiary 1 and 10,000 to beneficiary 2, it keeps 30,000. Then they each pay 10,000 on tax, and the trust pays tax on 30,000. And the trust is in the highest bracket at about 12,000. So you can play with that and you could say, well, I'm going to have income in this complex trust. It's not going to be taxed to me. And then the trust is going to pour the income out on my deserving children and grandchildren based upon what works best for them. And you want to do this usually by December 31st of each year because the trust is on the calendar year. But there is a 45 or 65-day rule, I forget which one it is, where early next year you can pour out the income and it counts for the prior year on the trust return. So maybe that's why they call it a complex trust. Then you have the ESBT trust, the electing small business trust, which can own S corporation stock. A complex trust that owns S corporation stock makes an ESBT election in order to allow the S corporation stock to be owned by it. Otherwise, you could lose your S election. And then the S corp pays the income tax on that stock. And that's at the highest bracket. So ESBTs are not as popular as they used to be, because they used to be you didn't have to pay tax at the highest bracket on an ESBT. And then you have the QUIST, QSST. It has nothing to do with orange juice. It requires all income to be paid out to beneficiaries. So the K1 from the S Corp stock owned by the QUIST actually kind of goes to the beneficiaries whether they get the money or not. So the QUIST is another planning method. And you have to kind of consider these to decide what to do for your children after you decide that you want to do something for your children. So another entity that could own S Corp stock is a charity. And there are ways that you could own part of the stock of an S Corp and a charity could own part of the stock. And then the charity pays tax on its part of the S Corp income. So I could get into rabbit hole after rabbit hole of discussion. There are things that are worth considering. Even with a medical practice that cannot be owned under state law by non-doctors, you could do this 199A planning by setting up a practice management company. Marty Shinkman and Jonathan Blattmacher and I wrote an article on this a few years ago. I'm glad to share it if you like. If you send me an email that says RE article, Brittany will be talking about this article if they put the word article in the RE line. And what you can do is set up an arm's length management agreement where the doctor agrees to work under an employment agreement and agrees that the management company will be paid a management fee. The management company gets the management fee, and then it could be owned by Section 678 trusts. Another idea that we've written about is the ELOPE, E-L-O-P-E technique. And what the doctor does here is sets up a factoring company at arm's length, a family partnership owned in trust for the children, loans money at 10 to 12% interest unsecured to a factoring company, partly owned by the child. The factoring company buys the accounts receivable from the medical practice. So the medical practice doesn't have accounts receivable. This is a great business reason to do this because it's going to save income tax for the family by diverting income to 678 trusts or children. And by the way, if the doctor gets sued for malpractice, there's no accounts receivable because they are regularly factored. So if you have clients who have a lot of accounts receivable, this would be a good technique to think about for those children and grandchildren. And this is part of our 199A book. If you're interested in our 199A book, we will someday update it, but it's still up to date as far as everything practical. It's just a couple of years back on what the brackets are and things like that. So now we go to my UJA talk next Wednesday. Don't tell anyone that I've let this out of the bag, but charitable remainder unit trusts can be a great way to help children and also help charity, and quite candidly, convince your spouse that giving to charity is a good idea because of the tax savings and the restraints that you can put. So we call this the self-policing charitable remainder trust. And what it is simply a trust where the client can put $100,000 in our example into 3 separate charitable remainder trusts for their 2 nephews and 2 nieces. This family all goes to the same church, and they have promised the church that they would do charitable remainder trusts, and their CPA goes to the church, and the nephews and the nieces don't have a lot of investment experience, but eventually they'll be inheriting significant amounts, and we'd like for them to have some investment experience. So if we put a $100,000 donation of appreciated stock into a charitable remainder trust for George, who is age 55, then that trust could give George 11.84% of the value of the trust assets every year for George's entire lifetime. And what's left in the trust when George dies can go to the church, or it could go to any charity designated by anyone giving a designation right in the document. And this will be considered to be a $90,000 gift for gift tax purposes and a $10,000 charitable gift. So the clients, if it's properly drafted, will get a $10,000 charitable donation deduction. So if they itemize, that will save them $3,700 in taxes, which is not a huge amount, but it's still worth doing. If, on the other hand, George gets 6.92, excuse me, thank you, 6.92% unit trust interest, every year he gets 6.92% of the value of the trust, then they're going to get a $21,000 tax deduction. And if instead of going for life, it's a 20-year payout, then George would get a 10.87% per year payment. Now, if you'd rather go with the charitable remainder annuity trust, the numbers would be pretty much equivalent, a little less as far as what George receives, but George would receive a standard dollar amount each year for the rest of his life. Now, Kathy's only 40. So to get her a lifetime payment with a 10% remainder interest to charity, which is what the charitable remainder trust rules require, she would only be able to get 6.92%, or again per year, or again on a 20-year payout, 10.87%. So I think it's a good way to have the child be the trustee, if you like, have the CPA meet with them every year. The fees for the CPA and for filing the charitable remainder trust get paid from the trust itself, not mom and dad, but everybody's watching to make sure the child doesn't take too much out. So that's why I call that the self-policing charitable remainder trust. And as we know, Larry Katzenstein will be joining us fairly soon, not today, but another day, to talk about how you figure out all these numbers. But if you're going to go with this is based on June 2020, it's a little bit different now. But if you're going with a 30-year-old, you would give them no more than a 5.31% distribution each year for life. A 40-year-old, 6.9%. 50-year-old, 9.6%. A 60-year-old, you could give them 15% a year out of that trust and still get that 10% charitable deduction. If you went with two 40-year-olds, you'd be at 5.12%. Because the annual distribution needs to be at least 5%, you can't go below two 30-year-olds jointly. So that may help you if you're doing this type of planning. You may want to print out this page and this page and then laminate them and take them into the hot tub and discuss them with your significant other. Or if you're having a hot tub party, you could have a charitable hot tub party. And when it gets cold in the winter, which seems long away, by the way, that could be used. In addition, when you're thinking about your children and charity, remember that Uncle Sam is a 40% beneficiary on a wealthy person's estate plan. But if that wealthy person leaves assets to a charitable lead annuity trust, then charity gets annual payments for 15, maybe 20 years. What's left goes to the children, which could be more than the 60% they would have gotten after taxes. And the children can run the private foundation that receives these 15 annual payments. And then they can take a salary, a reasonable salary, from that charitable foundation. Or when you die, you could leave everything to your private operating foundation, but give your children an option to buy the assets that you leave on death from the foundation. So then the children, let's say it's a $100 million company, you could leave the company to the children and pay a 40 million tax, or you could leave the company to the private operating foundation and have the children owe 100 million to a charity, and the children can control the charity and pay interest only at the applicable federal rate, which right now would be a little bit over 3%. And so they would pay, in my example, $3 million to charity every year, which would be tax deductible, as opposed to paying $40 million to charity. And then they could renegotiate the note with the charity and prepay it if the charity forms a school or a church or a medical research organization or a clinic that meets the definition of hospital, because then it is what we call a public charity. Now, the IRA sprays income. I remember Professor Dennis Calfee saying it's like a hose. You get hosed by all this income. So the IRA is payable to Child A if you don't want, or you could do a teapot trust. And then Child A says, I don't need it. I'm glad that Dad made the family foundation the alternate beneficiary of the IRA payable to me, because I'm disclaiming part of that IRA and I'm letting it go to my charity. So that's a good use for an IRA. Or the IRA pours into the teapot trust, which is a complex trust, and then the teapot trust is able to transfer that income to the charity if it is permitted under the trust agreement in order to qualify under what we call Section 674, which we could do a whole hour on Section 674, and you wouldn't like me at all. So another idea is the IRA is payable to the child, who can disclaim it to a charitable remainder trust, which then pays the child for life, and then the child doesn't have to pay the income tax on the IRA except when they get payments from the charitable remainder trust. Or the charitable remainder trust could actually disclaim it to the charity. So you can have a lot of choices. We just did a very, very large estate plan, and the client is giving the choice through a trustee for the child to decide whether it's going to go into the charitable lead annuity trust or to the charity. and there's 4 children, so each child can ask the trustee to make a different decision for that child. So I have coincidentally ended on time. Once again, please do join us for Charitable Remainder Trust discussion next Saturday. And then on October 1st, Larry Katzenstein will be joining us at noon after I talk about mathematics of estate planning. Donald Duck is invited, but I don't know that he'll attend. And then we'll be talking about a basic estate planning checklist on Saturday, August 8th. The Thursday report recently came out with Queen Elizabeth, and what I learned was a lot of people they don't like the royalty, and they don't like what the royalty's done for the few thousand years. And I have to respect that. Everybody has their own opinion, but it was interesting to get that feedback. But there's other articles in the Thursday report. If you are not a subscriber to the Thursday report, it's free. It's probably only worth about what you pay for it, but we'll be glad to share it with you if you just email us and ask us to put you on the program. So, Brittany, we are ready now to have the amazing Travis Fincham, a very responsible professional and a lawyer who is very passionate about helping people with special needs and financial needs, and helping make sure that the government helps your family in time of need. So thanks very much for listening to me. I had a great time, as always, and we'll see you next week, and appreciate your input. And also gifts of candy. Thank you.
Hi there, I'm Travis Fincham, and we're going to be talking about Florida Medicaid and some other eligibility planning tools for estate planners. I understand that there's going to be attorneys, and I know there's financial advisors. I kind of know what Alan's population, his group is. So I'm going to try to gear it for an introduction to some of this. And there'll be opportunities if we want to have additional programs down the road. You can tell Alan if you want to know more about it, or as we get into some of the strategies and the things that we do, we can talk about that as well. But I wanted to give you an introduction because there's a lot of misunderstanding and kind of misconceptions about what Medicaid is. And so that's what we're going to talk about. This is my firm. We are special needs lawyers here in Clearwater, Florida. We have 4 board certified elder law attorneys, which is kind of the specialty you're going to get into if you're talking about Medicaid and public benefits. We got Charlie Robinson and Linda Chamberlain in the middle. On the right there, Travis Fincham, and then Cole Long is our other attorney. So the basic topics that we're going to talk about as we start here, we're going to talk about the Florida Medicaid programs. May get into a little bit of some of the strategies that we utilize based upon time, but probably not today. We're just going to talk about the programs themselves. And there's opportunities to get into planning strategies for a future time, as well as special needs trusts and how those factor in, because you probably do see those and you probably do cross paths with special needs trusts. And those are often one of the planning tools that we use when we're trying to either gain or maintain eligibility for some of these programs. And again, we're gonna talk Medicaid. So the first thing is I'm gonna say what we're not gonna talk about. We're not going to get into Medicare, and I have to tell you that basic difference between the two programs is a big deal, and most professionals even don't necessarily know the difference. They think Medicare is Medicaid, and hopefully you know a little bit about Medicare. That's a health insurance program through the federal government. We'll talk about Medicaid is not a federal program. It's administered by the states. So the federal government has a couple of healthcare programs. One is Medicare, the other is veterans benefits for those that served and their families sometimes. But Medicare is based on having worked and having paid into the system. So most of you may know Medicare you get at age 65 if you've been working and you've put enough quarters into the Social Security system. Or if you haven't, maybe your spouse has, and you're going to be able to draw Medicare benefits on a spouse. You may also know Medicare as a benefit for people who are trying to work and get to retirement, but become disabled and go on disability, and again, have still worked enough and paid into the system, but didn't quite make it to retirement age. Those individuals can be eligible for Medicare. And then finally, there's another population that gets Medicare, and those can be dependent adult children, sons and daughters, who have never worked enough in their life to be able to qualify for Social Security and therefore Medicare. And there are circumstances under which they can draw on a parent's work history. Medicare is medical coverage, hospital, doctors, prescription for Medicare Part D. So that's health insurance, and it's based upon having worked and paid into the system. What about for everybody else? Either they have not worked enough or they can't qualify to draw on someone else's work history. Well, that's what the Medicaid programs are designed for. Medicaid are state-administered healthcare programs. They also do medical, hospital, doctors, prescriptions, but they have other benefits and programs that Medicare and your private insurance doesn't cover. And those include long-term care types of services and some other very specific services for individuals with a very particular diagnosis. We're going to talk about that. We're going to focus on the Florida programs. I know there may be a few of you who are not Florida-based, but there'll be similarities from one state to the other. Some of the terminology that we may use here in Florida is specific for here, but there's Medicaid existing in every state in varying degrees. And in order to understand that, we got to go back a little bit in time and in history to 2014. 2014, a lot of things happened, but one of the things was the introduction of the Affordable Care Act, Obamacare. It was designed to help those individuals who did not have insurance, maybe through employment or a group plan, or who could not get private insurance because of pre-existing conditions, and we wanted to get coverage for them. So what we did was allowed for individuals who were working but maybe not enough to, or at an employer where they're going to get group coverage, to buy healthcare coverage and to buy on an open market with competition. And so the way that the Affordable Care Act was designed was to give tax credits to individuals based upon the amount of income that they had to help offset the cost of going and buying private insurance. But what about for the individuals who either didn't make enough money to even qualify for those tax credits? There was a floor that was set on the Affordable Care Act. The design was that everybody under that would be eligible for their state Medicaid programs. And at that time, the federal government said, we understand this is going to expand people into the Medicaid rolls. Therefore, the federal government is going to cover 100% of those enrollees' costs. And we're going to talk in a couple of slides about how much the federal government contributes toward Medicaid, but the federal government said, we're going to cover 100%, at least for the first several years. And then after that, the federal government will cover 90%, because we understand states, this is going to put more people in your Medicaid rolls. So the idea was that states would apply for those benefits and get those funds from the federal government. Well, the reality is that as of right now, still 12 states have not expanded their Medicaid coverage for the population that the Affordable Care Act was designed to cover. And again, I'm going to talk a little bit about all the different Medicaid programs that are available here in Florida, but just to give a little hint of one of the things we're going to talk about is that Florida did not expand Medicaid for individuals who were just under a certain income threshold. In Florida, to get Medicaid, you do have to be under certain financial limitations, but you have to have some other hook that gets you into the Medicaid system. You can't in Florida just be poor and get Medicaid. And when we get to the different Medicaid programs that we have here, we'll identify why that's the case. But so Florida, as you can see from this slide, is one of 12 states that have still not adopted the Medicaid expansion. So Florida is not getting that percentage or that pull down from the federal government. So why is that important? Well, the next slide is going to illustrate it. But as you can see, most of the states are kind of down here in the Southeast. There's some in the Midwest, but there's 12. And this is from the Kaiser Family Foundation's website, where they track all this information. And each year, and states have gradually, there was about half in the beginning, and we're now down to only 12 that have not. Eventually, they're all going to get into it. Obviously, there's some political reasons why this is not happening, and we're not going to get into the politics of it today. I'm just strictly talking about the finances of it. And this is a big issue, and it's a big deal for us here in Florida, because you're going to see in a few minutes what the financial burden is to the states. So Medicaid, even though it's administered at the state level, comes with many matching funds from the federal government. And those funds, this next slide kind of illustrates, are called the FMAP. It's the federal matching, I forget what the A stands for, but the funds. So I know this chart is a little difficult, and you got to kind of know what we're looking at here. But for our federal dollars, as of right now, this was just updated in August, we are anywhere between 67% for fiscal year 2021 to 22, scheduled to go down to about 60% of federal dollars. So what that means is about 2/3 of our dollars that we use for Medicaid here in Florida comes from the federal government. The rest comes from the state of Florida. So, okay, so what's that mean as we're talking dollars and cents? Well, just to give you an idea on a few of these. So as of July in Florida, July of 2022, there are about 5.4 million residents in Florida who are on Medicaid, that receive their medical coverage through the Medicaid system. Since October of last year, in about 8 months, it's gone up 8%. And if you look month to month, the rate of increase is about 1% per month. So, okay, so what's that mean? 5.4 million Floridians. How many people live in Florida? Right now in 2022, we're about 22 million people. So what does that mean? It means a quarter, 25% of our residents in Florida receive their medical coverage through Medicaid. 1 out of 4. And the dollars are a whole other story, but it's billions of dollars, including even the 25 to say 40, 35% that Florida puts in, depending on the program, is still billions of dollars of our state budget. But when we say Medicaid, what does that mean to most people? For some who deal in long-term care and maybe the elders and dealing with people with higher net worths, which I'm assuming some of you are, when we say Medicaid, you may immediately think and go to, well, that's the long-term care program that we have in Florida. That's what helps people, because unfortunately it was decided way back that needing long-term care and the daily help of an individual with bathing, dressing, going to the bathroom, things like that, that's not a medical issue, even though I think most of us would agree that it is. But that's not covered by our health insurance if you have private insurance, at least not for very long. And it's not covered by Medicare. Remember, we talked Medicare, hospital, doctors, prescription. There is a little bit of rehabilitation available through Medicare, but most you get is a few months. And if that's not enough time to fix you up and put you back out into your home or back out into the community, so what? Medicare and health insurance stops. So unless you can afford to pay $9,000 or $10,000 a month if you need skilled nursing, 7,000 or 8,000 a month if you need memory care, 5,000 to 7,000 a month if you need assisted living, or you just need help in the home to be able to stay there and maintain your independence. What are you going to do? And so Medicaid has a long-term care component to it. But of that 5.4 million people in Florida that are on Medicaid, how many do you think get long-term care services in any of those environments I just mentioned? Nursing home, assisted living, memory care, or at home? Well, in July, it was 124,000 people, 2.3%. So 2.3% of our Medicaid population is getting long-term care services. The rest, and the vast majority, are just getting the health care, the medical coverage. So how does that compare? We're at 24.5% of our population gets their medical coverage through Medicaid, and we haven't expanded Medicaid to enroll people who don't have, again, another hook, which we're going to talk about in a minute, not just the poor people who are reasonably healthy, are working, but don't have insurance, or are working and don't make enough to trigger those tax credits. Well, nationally, as of May of 2022, about 89 million individuals are on Medicaid benefits of some sort. And if our population is somewhere around 332 million, it's 26.8%. So we're at 24.5%. And nationally, even in those other, 32 states that have, or 38 states that have expanded Medicaid, it's about 26.8% of the population. So in order to encourage the states to expand Medicaid, back in 2014, I mentioned that the federal government said, we're going to cover 100% for the first couple of years. And then after that, we're going to cover 90%. So those other states that have expanded, yes, they have pretty substantial Medicaid rolls, but the vast majority of those individuals are pulling down the federal 90% figures. It's a much smaller burden on the state. But what happened? Florida didn't do it. And we're now, it's 2014, so we're 8 years post, and we still have not. So what have we been doing? Well, we're still paying 40% or so, say 35 to 40% out of state funds, because the federal government's not pulling down that big amount. It certainly impacts our state budget, but the federal government has been trying to give states incentives. And so what they've said for those that still continue to convert over, and each state, it slowly is, Florida has considered it, but has not. For this year, the federal government will give a 5% bonus for the first 2 years. So instead of the 90%, they'll do 95% for a couple of years. And then it will go down to the 90% that the other states have had. Originally, the 100% was only available for those that adopted it in the very beginning and adopted it for those first 2 years. So even those that did not and are still lagging behind still can get that little bonus. But if Florida doesn't act, we're not going to get it. And the short answer is we're paying for it anyway, right? Here in Florida, we're either paying for it because the people are on Medicaid, or what they do is they just, if the uninsured have a major medical need, what do? They just show up at the hospital anyway, and we have to treat them. And we have to provide them at least basic medical care. And who pays for that? I mean, we all do. I mean, the hospitals pay for it, and we all pay for it with higher medical expenses. So we've got to figure this out. It's a growing issue. It's a major financial issue here for the state of Florida. So let's talk about how we get Medicaid in Florida and what are some of the eligibility criteria. This chart is, this list is off of our Florida Medicaid website. And basically, again, Medicaid is medical coverage, but it's other things as well. But because we did not expand it to people who were just under certain eligibility thresholds, you still have to have another hook. What are those hooks? Well, the hooks are you either have to be a child or a parent of a child or a pregnant woman. We do have foster care individuals who were formerly in the foster care system and then age out of that still get coverage through Medicaid. We have some emergency medical provisions for non-citizens. And then we have the last category, which is for our aged and disabled individuals. So aged and disabled individuals is a big area where we as elder and special needs law attorneys deal with that population. And we're going to talk a little bit about that. But on the others first, because Medicaid is not Medicaid is not Medicaid. There's different benefits available, and there's different doorways to get into these Medicaid programs. And one of them I wanted to refer to, and it kind of talks about it down here. It says, disabled individuals not currently receiving this program called SSI. So one way to get Medicaid in the state of Florida is if you apply for disability benefits to Social Security and you say, I can't work. I'm under the age of 65 and I can't work because of some medical reason. And if Social Security does their evaluation and they say, yes, you meet our definition of being disabled, you're unable to work and make a minimal or certain amount of money on a monthly basis because of this medical condition that we all agree prevents you from working at that substantial level. You can then say, okay, I'm now disabled. Am I eligible for anything Social Security? And the first thing Social Security looks at is, okay, have you worked? Did you put enough quarters into the system so that you can now start drawing on those quarters early since you didn't quite make it to your retirement age? If so, that's the program I referred to earlier as Social Security disability. That's based upon working, paying into the system. The amount you get back is based upon what you put in. And eventually, after a 2-year wait of being eligible for those income benefits, you become eligible for Medicare medical coverage we talked about before. But if they say, okay, you didn't work, you haven't paid enough into the system, the next question is, can you get Social Security on someone else? You're not retirement age, you're disabled, you can't work. Odds are you're not going to be eligible to draw on a spouse's work history. There is a disability benefit for a person who becomes disabled and they haven't worked, but their spouse worked. But that's still for a little bit of an older population, over 50, I believe. There's that program I referred to earlier of being able to draw on a parent's work history, a disabled adult son or daughter who's never worked enough in their life. That's called a disabled adult child benefit, DAC. It's also called childhood disability benefits. That amount is based on how much the parent put in, and that benefit comes with Medicare. So again, we've gone through all of these programs. Social Security's like, nope, not that one, nope, not that one, nope, not that one. And they say, well, the only other program you might be eligible for through Social Security is this SSI program. Stands for Supplemental Security Income. It is welfare. It has no basis upon having never worked. It doesn't pull money from the disability or the retirement trust funds with Social Security. It pulls from general revenue, and it's a welfare benefit that gives the individual a monthly check up to, in Florida, $841. I say in Florida because some states, especially up in the New England area and out west in California, add a supplement to it because 841 is not going to get you very far in most of California and New York and some of these other states. It doesn't get you very far in Florida either. But it gets you a check, and what it gets you is it automatically gets you Medicaid medical coverage in Florida. So an eligibility for SSI determination by the federal government triggers a notice to the state of Florida that says, hey, Florida, you've got a person down there who's going to start receiving SSI, and they immediately become eligible for Medicaid. There's no application that you file in Florida to get that. It's automatic. Of those millions of people, the 5.4 million in Florida, the vast majority get their Medicaid that way. The state isn't really even involved in the determination, other than the state has this agreement with the federal government that says we will automatically give Medicaid to those Florida residents that are eligible for SSI. Social Security's done their determination that the person meets all the medical criteria, the disability criteria, but SSI is also a welfare program. So you've got to be under certain income and asset levels, which we're not going to be able to get into all those today, but those levels are somewhat tied to some of our Medicaid levels. So there is this SSI benefit that gets you Medicaid. Also, a lot of our Medicaid residents in Florida are the family Medicaid. So family Medicaid is a whole other track and a whole other set of eligibility criteria. Those are the ones that are going to come in the first couple of categories here. Children, parents of children that are caring for them, pregnant women, those are family Medicaid recipients. Family Medicaid in Florida, and this is just adding to the complexity of all these different Medicaid programs. Family Medicaid in Florida is only based upon income. There are no asset or resource tests for family Medicaid. You can have $1 million in the bank, and if your income falls, and this is a busy chart, I know, and it's somewhat complicated, but this is the family-related Medicaid income limits. So depending on how many people you have in your family household, you go across the column, or you go across the different columns to get to 100% of the federal poverty level is one number, and then depending on whether you're an adult or you're a pregnant woman or you're a child, it gives you what your monthly income can be and still be eligible for that program. I don't do a lot of work with the family Medicaid folks. They're either eligible or they're not based upon income, but we need to recognize it as professionals when someone says, yeah, I'm on Medicaid, we need to ask, why? How do you get Medicaid? You get it because if you're on family Medicaid, your household income is under a certain level. Assets don't matter. The program that we do a lot of work with, and I'm actually going to go backwards on my slide for one moment, are the programs down here at the bottom, which are for the aged and disabled who don't get SSI. And it's 124,000 people statewide. It's not a lot of people. So all those elder law attorneys and the long-term care and the nursing home, cases that you hear about, they're all competing for basically 124,000 individuals. For that group, because remember that SSI program is related to Medicaid, this is another busy chart. I know you can't read it and you may not even understand what a lot of it means, but what I wanted you to see about the next two slides are what they're actually, the titles of the slides, so that you can go and search for them if you want to. This is a chart that's called the SSI related Medicaid programs. And so all these programs that are just set by their abbreviations, the next two slides I'm going to go through explain a little bit about what those are, but what I wanted you to see is that these programs have not only an income limit to them, they have an asset limit. So not only does your income need to be under certain levels, you have to have certain resources under certain levels. And that's where a lot of us that do this type of legal work are advising clients that come in and they're either not under the income limit or they're not under the asset limit, and they need to be in order to qualify for the program. So we help them navigate the program and what you can and can't do in order to become eligible. And so again, these are all a bunch of abbreviations. What do they all mean? There's a booklet, and I wanted you to just see the name of the booklet, and it's called the SSI Related Medicaid Fact Sheet. If you just Google that, you'll find, as I did this morning, I was still working off of one of these booklets that was from last year, August, because I didn't think it had been updated. And then when I looked at this morning, there's a June 22 update. So this book, it's about 20 pages long, but what it does is it takes all of those programs that are on the prior slide, the ICP, the HCBS programs, MedsAD, QMB, all these different Medicaid programs, and it explains basically what they are and additional eligibility criteria for them other than just straight income and asset test. But what I've also done is I've taken those programs and I've just broken them out onto a slide, and this is going to be our last slide. These are the Medicaid programs that are available to us currently here in Florida. These are the SSI related programs for the most part. The family Medicaid isn't even on here, but I want to mention what each one of these are, and or not most of them, not all of them, what the big ones are, and kind of what the population is that deals with them. And then with that, we'll probably be about out of time. So the first category we already mentioned are SSI eligible individuals, that federal supplemental security income program. Eligibility for that makes you automatically get medical, Medicaid, health insurance, hospital, doctors, prescriptions. It does not get you long-term care benefits. That's program number 2 and another one down lower. The institutional care program is our long-term care program. For that program, the federal government gives us about 2/3 of the dollars, because that's our drawdown, to then help people who have either exhausted their funds or qualify for the program and need long-term care benefits. The ICP program is only for those individuals who are in nursing homes. If you're somewhere else, what has to happen there is we had to get the federal government to waive one of the criteria, in this case, institutionalization, to provide services out in the community or maybe at home. That program is number 8 on the list, home and community-based services. They're oftentimes called the waivers because the state of Florida got the federal government to waive one of the requirements, in this case, institutionalization, to provide services for people who are elsewhere. Some of these other Medicaid programs, there's a program called Protected Medicaid that I actually do deal with pretty frequently. In that case, an individual who has been eligible for SSI and gets the Medicaid, number 1 up here, the SSI eligible individuals, gets the medical coverage there, but then they end up losing their SSI in the future. And the reason that they lose it is because they become eligible to draw on someone else's work history, either a spouse or a parent at some point. When that happens, if the amount that they're eligible for is over the SSI figures, they lose their SSI and they get the larger amount. Well, that's great, but they initially would lose the Medicaid that's tied to it. Protected Medicaid says no. As long as they still remain eligible in every other way, they keep getting the health insurance part of Medicaid. And when that usually is happening is a son or daughter with a developmental disability, that parents either start drawing Social Security or retire or pass away, and then the child starts being eligible for a check, and they'll start receiving the check on mom or dad's work history. They'll start the 2-year wait for Medicare, but they keep Medicaid the whole time, even after they become eligible for Medicare. And then Medicaid becomes the supplement. So that's Protected Medicaid. Medically needy is health insurance Medicaid for individuals who meet, again, disability definitions and other things, but maybe their income is a little bit over the income limit. There's a medically needy program that provides major medical coverage. Of the other ones on here, I mentioned the home and community-based services, the waivers. We have 2 major waivers and some other minor ones. The 2 major waivers are long-term care, getting services at home and in the community, and we have a waiver for those with intellectual and developmental disabilities. That's administered by the Agency for Persons with Disabilities, APD, and the state puts funding into that. Again, the bulk comes from the federal government, but funds go in there to help meet the unique needs of individuals with those diagnoses. Unfortunately, it's not funded very well, and there's more people on the waiting list than get services, but it is a program that's on there. The only other ones I wanted to mention are down toward the bottom, which is something called Qualified Medicare Beneficiary, QMB, and the SLMB and the QI1. These are benefits for people who get Medicare, but they still don't have much in resources so that they can get Medicaid to supplement Medicare. Because as you probably realize, for a lot of our retirees that have Medicare have a secondary insurance policy, they have a supplement. because Medicare pays 80% of most customary types of services, and then you got to have that supplement that pays for maybe some co-pays, deductibles, and that 20% copay. And individuals who can't afford that coverage or can't get it, the QMB program provides them with that supplement so that they have that coverage and can pick up the 20% that Medicare doesn't pay. So these are some of, again, there's more detail to it, but some of the Medicaid programs. I wanted you to have that background of kind of how it ties in with the state and federal funding and where we're going. There's still a lot of changes coming. This is a big concern for our politicians in Florida because Medicaid is a big chunk of our $100 billion budget is what the state is functioning at right about. And so there'll be a lot more to come. And there's a whole lot more we could talk about this. If you're interested in that and you want to hear more about it, let Alan know, and we'll see about trying to get it on one of the future programs. Okay? Thank you for your time and attention, and enjoy the rest of your weekend.
Okay, thank you very much, Travis. That was absolutely excellent. So much better than the garbage that Alan had to say. Anyway, we hope that you enjoyed this presentation, and more importantly, we hope that you'll take the information that we gave you and forget it as soon as you can, or use it to help someone. Thank you very much, and I do accept emails to the dummy, the dummy, D-U-M-E-Y, at gassmanpa.com. Thank you again, and I've said thank you way too many times. Bye.